So these are the people versus J.C. Owens. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0 because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
Before we even get into the courtroom fireworks, let's be very clear about what you're about to witness. This is not a misunderstanding. This is not confusion. And this is definitely not someone being treated unfairly. What you're watching is a repeat offender walking into court believing that word games, half answers, and selective memory are going to magically erase accountability. On the other side of the bench, a judge who has seen this exact performance more times than she can count, and who has absolutely no patience left for it.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plea. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
Right here is where the tone of this case quietly locks in. The judge's comment about thieves suddenly finding money after they're caught isn't sarcasm. It's experience talking. Judges hear these cases every single day, and patterns matter. When someone is willing to pay restitution immediately but couldn't be bothered to pay at checkout, the court notices. This isn't about whether the items were recovered. It's about intent and credibility. What's important here is that the judge is already evaluating whether this defendant is being truthful, and once credibility is gone, everything else becomes harder.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
This moment right here is where everything starts to unravel. That long pause isn't confusion, it's resistance. Courts don't require emotional confessions. They require clear factual admissions. When someone suddenly doesn't know how to answer, judges hear that as avoidance, and avoidance is deadly in plea hearings. Notice how the attorney tries to step in and reframe the situation as an attempt. That's actually a legal distinction that doesn't help here, because under the law, attempting to steal and successfully stealing are treated the same in this context. The judge knows this. The prosecutor knows this.
All right,
Yes,
I can't
ma'am.
accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
No,
if
you're
I,
not guilty. Miss Owens, you've been through this before. You've got
Yeah,
a ton of
I'm-
larceny convictions, right?
I'm
This isn't your
confused
first
on
rodeo.
which-
And ma'am, you're not required to enter a plea of guilty. But if you think you're
No.
gonna sit here, I'm talking. If you think you're gonna sit here and tell me that you didn't do anything wrong and think I'm gonna accept your plea, you're sadly mistaken. I'm happy to have a
I'm
jury
confused.
trial. I like nothing more than a
I'm-
jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date.
This is a courtroom equivalent of slamming the brakes. The judge isn't being dramatic. She's protecting the integrity of the plea process. Courts cannot accept a guilty plea unless there's a clear factual basis. That protects everyone, including the defendant. And listen carefully to what the judge says here. She's perfectly happy to go to trial. That's not a threat. That's confidence. Judges who are afraid of jury trials don't say that. This judge knows the evidence, knows the record, and knows this defendant's history. At this point, the defendant has lost control of the situation entirely.
That makes you guilty of larceny.
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All
But
right,
it
so
doesn't,
that's a not guilty plea. So, okay, we're gonna just go ahead and set these both for
but the
jury
second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan
No.
$250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that
first
scanner.
case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
What you're seeing here is something judges absolutely despise. Someone being given a second chance and immediately wasting it. The question is simple. What did you do that makes you guilty? Instead of answering it, the defendant launches into excuses, minimization, and contradiction, and here's the problem. Intent is proven by actions, not explanations after fact. 8 items, $250. Self-checkout. Those facts don't disappear because someone claims it wasn't a steal. The judge isn't confused. She's done. This is the moment where the court officially decides that a jury trial is the only option left because the defendant refuses to meet the bare minimum requirement for accountability.
We're going to jury trial.
Your
I'll
Honor,
set a jury trial date and we'll see you on that date.
There was
Your
a-
Honor, if I may have an opportunity to briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games
Ma'am.
she likes to play. She's lucky I
This
didn't
isn't
revoke
a
her
game.
bond the first time, and now she
Ma'am.
wants to play with whether or not she's responsible of this or not. And no, I'm not
not.
comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your
I
jury trial
didn't
date
say
in the
that.
mail. We're all
I
set,
did not
ma'am.
say
I'll
that.
see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry, I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial.
This is as clear as a judge can possibly make it without reading a script. You don't get to declare yourself guilty like it's a magic word. The court needs facts on the record, spoken out loud. This protects the system from false convictions and protects defendants from later claiming they didn't understand what they were doing. And the judge's final line here. If you don't like how the process works, then stop stealing. That's not sarcasm. That's reality. At this point, the judge has fully lost patience, and the defendant is one wrong sentence away from making things significantly worse for herself.
All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mickes, P76268 on behalf of Ms. Owens.
Miss Owens, tell me your name.
J.C. Owens.
Miss Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Miss Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items, Your Honor, without paying for them.
What items?
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
And there it is, the moment the entire case was waiting for. Once the defendant finally admits intent, the hearing moves instantly. No confusion, no delay, no drama. This is exactly how fast court works when someone tells the truth. The irony is painful. After nearly derailing her own plea, the solution ends up being incredibly simple. Admit intent, admit actions, answer directly. The judge's reaction here isn't cruelty. It's relief that the process can finally move forward. But by now, the damage is done. This plea comes with consequences, probation scrutiny, and very real risks tied to her existing felony status.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea, and you're going to meet with them. And I'm sorry, Mr. Mikos.
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're going to meet with the probation department, Ms. Owens, and they're going to contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay. We're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
This case is a perfect example of how accountability, or the lack of it, determines outcomes in court. The judge gave multiple opportunities, explained the law clearly, and warned exactly what would happen if the defendant continued playing games. In the end, responsibility was finally taken, but only after unnecessary escalation, wasted time, and increased risk to the defendant herself. If there's one takeaway here, it's this. Courts care about facts, honesty, and intent, not excuses after you've been caught.